All right, let's get started. As I said, we have three great speakers from eDepose today. Shawn Kennedy is the Chief Executive Officer. He is a litigator with 12 years of experience handling complex business disputes, including securities litigation and enforcement proceedings, professional liability actions, consumer class actions, antitrust disputes, and white-collar criminal actions at two AM Law100 law firms, most recently with Morgan Lewis. He has experience in all aspects of civil litigation, including taking and defending hundreds of depositions in federal and state courts. Shawn, thanks a lot for being here.
Thanks. Thanks for having me.
Yeah, it's good to have you here. Shawn is joined by Thadd Hale, Chief Operating Officer of eDepose. He has spent his entire career serving the litigation industry and has built his reputation around delivering quality products and services to law firms, corporate law departments, and government agencies. In 2005, Thadd founded eDiscovery, a well-known and leading eDiscovery company in the field, and was responsible for the technology vision of that company and managing and developing service lines as diverse as national sales strategies, data processing, forensic collections, web hosting, and attorney review. Thadd, it's good to have you here.
Yeah, thank you, Robert. Appreciate it.
And last but not least, we have Kevin Krusiewicz. He's a product specialist at eDepose. He is the customer-focused technologist who has been bringing emerging technologies and service models to thousands of small to medium-sized businesses since 2006. Formerly, he served as a sales engineer and product manager for a national cloud computing pioneer. At eDepose, he creates digital media assets, manages the product marketing lifecycle, oversees internal and customer-facing training efforts, participates in pre-sales product demonstrations, provides post-sale product support to resellers and end users, and lends his expertise in ongoing improvement of product sales and operations organizations generally. Kevin, it sounds like you have your hands full over there. Thanks for joining us.
Thanks, Robert. Glad to be here.
So I'm going to turn it over to these gentlemen in a second, but I want to first remind our audience to ask questions to the questions pane that you see on the right of your control panel. We're also offering CLE for this event, and Kevin, at the end of the program, will give us details on that, so stick around. Okay, again, guys, thank you very much for being here. I'll turn it over to you.
All right, great. Thanks again for that. So first thing we're going to talk about is depositions, and really kind of get into how important are they. Well, you don't have to be an attorney to know that how critical of a role they play in modern litigation. These days, if you're a public figure and you give a bad performance in your deposition, it's going to be all over the news and social media. If you have a Facebook account or watch TV, you probably heard of the trouble that Paula Deen got into when excerpts of her deposition transcript were leaked. Armed with the transcript, media members and bloggers were able to pick apart her words and bring to light things like her admission that she had used the N-word and some apparently racist attitudes about people who worked for her. It was a good example of how words in a deposition transcript can be used to very powerful effect after the fact. And then there's rap star Lil Wayne, whose deposition video has jumped to the top of the list of what not to do in a deposition. He came across as defensive and deliberately evasive, and that's before he outright threatened the deposing attorney. Lil Wayne said, he, referring to the discovery referee who was actually in the room to keep everybody on their best behavior, he can't save you, right? In the real world, that guy right there, he can't save you in the real world, just so you know. Thankfully, I've yet to have a witness say that to me, but I wouldn't want to have to face the other side putting up that video if that was my client. More recently, we had Justin Bieber. He put up a challenge to Lil Wayne for the most obnoxious celebrity deposition title with answers like, guess what? Guess what? I don't recall. And my personal favorite response, I don't know, Kate Couric. You tell me. And finally, Bill Gates famously showed that business executives are just as susceptible to bad deposition performances. Gates didn't testify in the US v. Microsoft antitrust trial, but the government used video clips from his deposition to great effect in winning its case, to the point where he's now the go-to example for why you have to spend extra time preparing the CEO for deposition. But even for cases that aren't so high profile, the fact remains that depositions are crucial. Many more cases are won and lost in a deposition room than are ever decided in a courtroom. That's why I like to call depositions the new trial. As trials have decreased in significance in recent decades, depositions have become even more crucial. And I see at least 3 good reasons for that. First, depositions are where witnesses get tested. It's one thing to argue in motion papers about what a document says. It's another thing entirely for a witness to explain what that document says when they're getting grilled by opposing counsel. In your conference room, that executive who works for your client may come across as very credible, but put her under oath in the deposition room with a camera interface and an unfriendly lawyer across the table, and the nerves can start to show. On more than one occasion, I've had the unpleasant realization at the end of the day that one of my client's key witnesses just wasn't going to play well in front of a jury. And that really changes the calculus going forward in that case. And second, as any politician can tell you, sound bites are very powerful. You might be extremely confident in the merits of your case. You can't wait to tee this thing up for summary judgment because you have the key documents that show exactly what happened and why the plaintiff's argument is baseless. And then you get to the deposition of the witness who authored one of those key emails. And you get a front row seat as that witness melts down in the heat of the moment and agrees with the plaintiff's lawyer that the text of that email actually means the precise opposite of what's written there. Can you rehabilitate that witness? Perhaps. But maybe the damage has been done, and you can see that one portion of the transcript featuring prominently in the judge's order denying your summary judgment motion. I've been in many a deposition where you could boil the whole 7 or even 17-hour exercise into a battle for 2 or 3 30-second sound bites. The third reason, even when you're not going for specific sound bites, witnesses can still lock themselves into testimony that damages their case. Some years ago, for example, I represented an inmate who had sued several sheriff's deputies for ripping out a body piercing from a very sensitive area during a strip search. The case boiled down almost exclusively to the word of 4 sheriffs against the word of my client, who had some credibility issues because he was serving a life sentence as a 3-strike felon. Well, at their depositions, just by asking some open-ended questions about the strip search, I was able to pin the deputies down to some very specific testimony about what they saw. And the 4 recollections couldn't have been any more different. At trial, I walked each of them through what they saw, using the exact words they used in their depositions. In the end, we were able to convince a federal judge that my inmate client should be believed over these 4 sworn officers because their deposition testimony showed that they had made up a cover story. And those are just a few examples, but there's no doubt at the end of the day that you could win or lose your case in a deposition room. Now I'm going to turn it over to Thadd Hale for a little background on the larger context of eDiscovery.
Thanks, Shawn. From the birth of litigation throughout the 80s and 90s, the entire discovery process was paper-based. Documents were collected in paper format, multiple copies were made, and these documents were reviewed one by one by hand. Many of you probably remember the copy label copy times 5 days. In the late 90s, wide usage of scanning was adopted, and within a 5-year period, the majority of discovery documents were scanned, OCR'd, coded, and loaded into concordance or summation for review. This allowed attorneys to keyword search and search documents based on coded fields. This was a huge improvement over the paper process. Around 2005, new technologies emerged and the eDiscovery revolution kicked off, and by the end of 2010, this was the new way of life for litigation teams. Documents were now collected electronically, processed, searched, and hosted in platforms like Relativity, iConnect, and Concordance FYI, to name a few. And in the last few years, we've seen new technology like analytics and predictive coding being used to speed up the doc review process and identify key documents throughout the review process. The current eDiscovery process has allowed litigation teams to become more efficient and drastically reduce the overall cost of litigation. Currently, the discovery process is almost 100% electronic until you get to depositions. Depositions are the last holdout to the eDiscovery revolution. Now I'll transition over to Kevin Krusiewicz, who will discuss the current paper deposition process.
Thanks, Thadd, for that. Thank you, Shawn, for it was entertaining even to listen to third hand here. Wish I could have been there for that testimony, but I want to go into the process at the deposition and how that connects with what Thadd was just describing. So what Thadd mentioned was that the discovery process has gone electronic already. We looked at that timeline a moment ago, and the process has evolved to a superior state from where it was 20, 25 years ago. And Shawn highlighted the importance of depositions. But in spite of how important those depositions are, in spite of the progress that we've made through that eDiscovery revolution, paper is still being used at depositions. So we want to look at that process real quick. So as was mentioned, most of the case documents are collected and processed electronically, and they're reviewed and issue tagged using expensive eDiscovery software, software that's required a lot of investment, time and money on the part of the law firm. And then what we're doing when we go to the deposition is we're hitting print, or we're hitting copy, and we're doing that multiple times. And that's obviously at a cost, and there's time involved as well. And then documents are foldered and boxed, of course costing time and money, and they're shipped, and that might be across town, might be across the state, across the country, or even across the world. More cost in terms of time and money. And then at the actual deposition itself, a small subset of the prepared documents are introduced as exhibits during the deposition. Maybe 10%, 25% of the documents that you have that you thought you might have needed are actually used at the deposition. And then after the deposition, your court reporting firm or a provider is going to scan those exhibits, maybe charging up to $1.50 per page. Of course, more time and money involved there. And then after the fact, exhibits are uploaded back into that electronic database for trial, where they might be displayed and blown up using, again, sophisticated, expensive trial presentation software. What's wrong with this? What's the problem with this process? Well, I want to make 4 points about this. I'm gonna make the case that it's inconvenient, it's inefficient, it's costly, and it's inaccessible. Number one, inconvenient. The printing, the foldering, the boxing of documents. Up until very recently, there really wasn't another way, so maybe we didn't see it as inconvenient. But in 2014, dealing with all this paper feels very inconvenient. Lugging or shipping those documents, so maybe you're responsible for dollying those up the elevator or picking them up from FedEx or UPS and getting them to your deposition location. That's not very convenient these days. And then the fact that you must attend the deposition in person in order to really track with the exhibits. Meaning, you know, if you're going to attend remotely and you have a live feed, you have a video feed, you have the transcript coming at you, once it is introduced into record, you're sort of lost. And so you really need to be on site in order to really track with the exhibits. That's inconvenient. Number two, it's inefficient. Paper is very intensive and it's a manual process. For any of you list support people on the call, any paralegals, you're familiar with managing copier vendors and managing the paper aspect, getting those bankers' boxes to the deposition. It can be very manually intensive. And then the fact that we're going from electronic into paper and then back to electronic doesn't feel very efficient to us these days. And we kind of wonder, couldn't there be a way to maintain some continuity throughout that process? Thirdly, it's costly. The printing, the copying, the foldering, again, the shipping, and then after the deposition, the scanning, and then storing and or destroying papers after the fact, very costly. Travel can be excessively costly. We're going to talk about that a little bit more in a minute. So excessively costly and then inaccessible. Kind of difficult to introduce new documents into the deposition, you know, during the deposition. If something becomes relevant where we thought we might not have needed it, but all of a sudden we needed that one document and it's back at the office, what do? Well, we fax it, we try to get it over somehow and make it available, you know, hopefully within a reasonable amount of time. waiting for exhibits after the fact. We're pretty used to waiting 7 to 10 days for the official exhibits to be returned to us by our deposition or court reporting company. And then multiple copies of the same document. So if you have a number of depositions that refer to the same document or exhibit over the course of a case, you might have had that document scanned and printed and scanned and printed and scanned and printed several times, and now you're dealing with multiple copies with quality degradation, and then you're wondering, which is the actual original copy and which is the copy that I need. And so paper is proven to be pretty inaccessible. The bottom line is that paper equals pain. Using paper exhibits is inconvenient, it's inefficient, it's excessively costly, and it's inaccessible. And it doesn't really match how we do things in our regular lives in 2014, nor does it really take advantage of the benefits of the eDiscovery revolution. So if you compare that labor-intensive process with paper with an electronic exhibits process, you can really see the difference. So in an electronic process, an electronic exhibit world, you're just setting up a deposition session online. You're uploading documents to secure servers to be made available to the deposition. At the deposition, the lead attorney, the noticing attorney, marks, introduces, and distributes the exhibits electronically. And then those that are logged in, either in the deposition room itself or at a remote location, are receiving the official exhibits or courtesy copies instantly via their preferred device. So again, look at kind of the streamlined workflow as compared to the manually intensive process we looked at, where we went from electronic to paper, then back to electronic. And so electronic exhibits really alleviate pain and add new levels of convenience. So we're not lugging boxes of paper around. Really, there's no paper involved. We have easier organization of documents during the deposition, and so we can get to those documents pretty much immediately, and that's very convenient. And we can take or even attend depositions remotely. You can have somebody in Boston taking the deposition and somebody in California as the witness and opposing counsel. That type of thing is possible, and it's convenient. Number two, new levels of efficiency, where you can mark and share exhibits electronically rather than the paper process that's manual and time-consuming at the actual deposition itself. For those of you that are paralegals out there and spend a lot of time with preparing documents for the deposition and making sure that all the right ones are there and that you have enough copies and that they're in the proper order, with an electronic system, Depo Prep is really streamlined such that you can access your electronic database and put those in the proper order, and they are available in that order to the deposing attorney. You can do that from the office. You can do that even from home because the internet's everywhere. And then thirdly, direct tie-ins with the eDiscovery process. So again, there's the efficiency that comes through that continuity of, instead of going from electronic to paper back to electronic, it's just continuously an electronic process. Thirdly, cost savings. No more printing, copying, shipping, or storing of paper, destroying paper. Significant cost savings. No overcharges for scanned documents after the fact. So that's a cost savings. And then potentially tens or even hundreds of thousands of dollars saved on travel costs for remote depositions. We've had general counsel at some large corporate clients tell us that if they had this back in 2012, they would have saved upwards of $500,000 in travel costs alone when you incorporate hotel and flights and food and all of the above. So if you can have part of your team attend remotely, you're saving a lot on travel. And then fourthly, accessibility, where new documents can be easily and quickly uploaded during the deposition, at the speed of an upload. Instant access to official exhibits immediately after the fact. So instead of waiting that 7 to 10 business day to get the official exhibits in your possession, you have them when you walk out the door. You can refer to them at your next deposition. You could even introduce them at your next deposition tomorrow in a different city, in your home city, what have you. And then finally, exhibits and transcripts can be easily organized with an electronic exhibit system where you can essentially walk around with a truckload of exhibits that are neatly filed away in your iPad or on your laptop, and you can refer to them at any time. You don't have to have somebody call those up for you. They're always available to you, and they're always accessible. And so because of the benefits that come with the use of electronic exhibits, there's a shift that's already underway. And that shift is going to continue over the next 3 to 5 years, similar to some of the shifts that we saw Thadd describing for us with reference to eDiscovery itself. But over the next 3 to 5 years, we're really going to see paper exhibits become largely a thing of the past at the deposition. And so it's important to ask yourself, is my firm or is my company or my corporation ready for this? And so to discuss how to begin making that shift in your firm or in your corporation, I want to turn things back over to Shawn. Shawn?
Thanks, Kevin. So as a litigator, I love being able to walk into the deposition room with just an iPad or a laptop instead of stacks or boxes of paper. I love being able to upload new documents on the fly instead of trying to find someone to print them out or get someone to fax them to me or to a friendly party wherever I am. So the benefits of electronic exhibits are pretty obvious to somebody who's been working in the system for a while. But understandably, a lot of litigators feel uneasy about making that transition. It's paper, I know. You just identify the documents you want to use, have someone print them out. You get a paralegal or associate to put them in folders or binders, box them up, and maybe arrange to ship them to the location. And yes, I know how to access the electronic documents I want, but how do I get them ready to use as exhibits during the deposition? And I know the potential minefields when dealing with paper. If I forget a document, it might be difficult to track down. We might not bring enough copies for everyone. It can be a hassle shuffling through all that paper during the deposition. You lose track of where Exhibit 54 is. But what kinds of problems might I encounter with electronic documents? Well, with those and other questions in mind, we've come up with 5 key tips to transition from paper to digital depositions. Tip number 1, get your documents into a usable electronic format. You already have your documents in digital format. They're hosted in an electronic database, which you or others on your team know how to access. That part's easy enough. But do you know what format they're in? Are they TIFF files, native files? If you're not having your vendor print them out, do you know how they can be exported? Some systems, like Relativity, have integrated tools that allow you to export your documents into text-searchable PDF format, for example. One way or another, it's likely that PDF files will be required for the electronic exhibit system you use. The electronic exhibit system likewise might have tools to convert other file formats like TIFF to PDF. But if not, you may need to allow some time on the front end for your litigation support staff or your eDiscovery vendor to convert your files to a usable format. Tip number 2, be careful about document size. Most lawyers don't give much thought to the size of a document until it's time to email it or perhaps e-file it as an attachment, and then they're running around scrambling, asking their lit support people or associates to figure this out. But when you're using digital deposition exhibit technology, you need to be mindful of how file size can affect performance. Are any of the documents you might want to use as exhibits large and unwieldy? A good rule of thumb might be, would it give you pause to try to email a document that size? Are you going to be having to think about sending it via FTP or something else? Simply looking at document size alone might be deceptive, though. A file might be large for a number of reasons. Maybe it's just a very lengthy document, or maybe it has a lot of images embedded in it. So you can't really avoid kind of the sheer size of it. But very often that big file might be larger than necessary due to the way it was created or converted in the first place, especially if it was not your team that created it. For example, I've seen a single page PDF that was more than 35 megabytes in size, which is pretty huge for a single page document. It turns out it was that big because it was created with numerous uncompressed layers of information. And by compressing that information before it was printed to PDF, we were able to reduce it to a manageable file size. The bottom line, though, is that you'll want to address things like file size before the deposition when there's still time to work with the document or substitute another version, for example. Look for possible trouble spots and work with your vendor or your IT professionals if you need to reduce file sizes or otherwise make documents more manageable. Tip number 3, efficiently organize your documents. With paper deposition exhibits, the paper is usually organized beforehand in binders and/or multiple file folders, so the deposing attorney can quickly access exhibits during the deposition. Sometimes when you've got a lot of boxes of paper in the room, you might even bring along an extra attorney just to run down documents during the deposition when they're needed. With electronic exhibits, you're also going to want to figure out a way to organize your documents for easy access during the deposition. You can organize your documents in a number of ways, depending on your preference and how many documents you're dealing with. For a deposition with a limited number of documents, it might be preferable to organize everything in a single potential exhibits folder. And you can just scroll through that folder to find the documents you need. But in a deposition with more documents, you probably will want to organize them a bit more. For example, you might organize documents by topics tied to the deposing attorney's outline. Some documents might be in a witness background folder, others in an expert qualifications folder, etc. Or if you're used to referring to your case documents by Bates number, you might have your documents organized in folders by Bates range. Whatever you choose, though, make efficiency the guiding principle. If you need to get your hands on a document quickly in the middle of a deposition, what method of organization is going to serve you the best? Tip number 4, establish file naming protocols. This one's related to the last tip, but it's drilling down a little further into how documents are actually named in your system. Typically, if you're exporting electronic files from an eDiscovery platform or your document management system, they may be named using their beginning Bates number, such as smk0001.pdf, or using a unique document ID number. Either of those may work for you if you're used to referring to your documents that way and you know them that way. But you may want to consider giving files a more descriptive name so you can quickly determine what they are, such as 10-413 Kennedy email. Alternatively, you may assign each file a presumptive exhibit number where you think you're going to maybe mark it, such as PX15, that's tied again to the outline that you're using. Whatever document naming convention you choose to follow, just make sure it will make sense to the deposing attorney during the course of the deposition. Tip number 5, identify and prepare all participants. If you're going to be using digital deposition exhibit technology, you should think beforehand about whether other members of your team will need access to the system to prepare your documents before the deposition. If so, be sure that everybody has the appropriate passwords, accounts, and any necessary training that they might need. And then there's other deposition participants beyond your team. You'll want to include a statement in the deposition notice, for example, that you're going to be using digital exhibit technology. You may also want to contact opposing counsel beforehand and let them know to bring a laptop, iPad, or other device. And you might think through whether your client or any other people related to your side, kind of outside your immediate team, may want to participate by attending remotely. If so, you have to make sure they're set up with any necessary hardware, accounts, or passwords beforehand. So those are our 5 tips for transitioning to electronic exhibits. Pretty straightforward, but important to make sure that things go well. Now I'm going to turn it back over to Thadd to talk a little bit about the factors to consider in selecting an electronic exhibit system.
Thanks, Shawn. So first off, we're going to talk about the non-negotiables when evaluating an electronic exhibit system. And I refer to these as non-negotiables because your typical attorney who's used to dealing with paper deposition exhibits is not going to want to switch to an electronic exhibit system unless it meets certain expectations. So number 1, the workflow must mirror the current paper deposition process. The reason most attorneys still use paper exhibits is because they want to follow a very familiar workflow in the deposition room. The electronic exhibit system you choose should mirror this process. Number 2, the deposing attorney's documents must remain confidential until they are introduced as an exhibit. Just like in today's paper process, the deposing attorney's box or binder of paper potential exhibits, that group of documents has to remain confidential until an exhibit is placed in front of the witness and courtesy copies are handed out. Number 3, each party in the deposition should receive their own copy of the exhibit. With paper exhibits, the witness and everyone else in the deposition gets an individual copy of each document. With electronic documents, you have to accomplish the same thing. So the witness can be looking at page 3 to familiarize herself with the document, while opposing counsel may be reviewing a different page at his own pace. Simply displaying a document on the screen for all to see through a WebEx or some other display technology doesn't accomplish that. This is the equivalent to the courtesy copy that's handed out in a paper deposition. And if the opposing counsel doesn't receive a copy of the document, they will probably not agree to use an electronic exhibit system. They need the ability to review the document at their own pace. Number 4, the system has to maintain the official version of the exhibits. While everyone should be able to mark up their electronic version similar to a paper version, the system still has to maintain one official version of each document so everyone knows what document the witness was testifying about. And it's important that everyone trusts how those documents were maintained. Ideally, everyone should have an open and immediate access to the official exhibits and not have to rely on one party to distribute them after the fact. Number 5, the system should be built on a database structure that allows the user to access any previous, current, or future depositions. Any attorney who is used to having documents available in an eDiscovery database is going to want to have the same ability with an electronic exhibit system. Specifically, they're going to want the ability to look back at previously marked exhibits from prior depots, and they're also going to want to share exhibits from one deposition with their colleagues who might be prepping for another deposition, or they might want to review and prep documents for use in future depositions. Number 6, the system must be backed up and secure similar to other leading eDiscovery products. Security is paramount in the litigation process, so you want to make sure your IT group is comfortable with the software, the infrastructure, and the backup procedure. Now I'm going to discuss some of the nice-to-haves when evaluating an electronic exhibit system. The system should be web-based to allow for remote attendee and device independence. Think about when you're traveling out of town depositions. It's very expensive, and a web-based exhibit system will allow the general counsel, insurance carrier, maybe the partner wasn't able to travel and sent the associate, but they will all have the ability to attend remotely and still receive the exhibit as it's introduced. The deposing attorney can also depose the witness remotely if they prefer. If the system's web-based, you won't have to rely on a particular device and having all of your data on that device if something happens. You can simply log in on another device and your documents and work product will be available. Number 2, integration with eDiscovery platforms. The ability to move potential exhibits from your eDiscovery database to your electronic exhibit system at the push of a button is a bonus. This process, compared to printing, copying and making multiple copies and then organizing in binders is much more efficient if I can work database to database. Number 3, chat functionality. The ability to communicate with team members who are in the room or attending remotely without having to take breaks or pass post-it notes is a great feature. Imagine corporate counsel or the corporate client, is in their office in New York, the deposing attorneys at a deposition in LA, but the corporate client's logged in. They can communicate with each other even though they're not actually in the deposition room, and it's secure, and only those two people see what's being chatted about. Number 4, an exhibit log. The ability to print or export an exhibit log on the case or deposition level can save significant human hours as the case progresses. Number 5, email. The ability to email documents or exhibits directly from the system allows the attorney to be better prepared. Let's say a hot document comes through and I'm opposing counsel, and we didn't know that this document was relevant or this person was involved. With the touch of a button, I can email that official exhibit to my client or maybe to my paralegal or lit support department and say, hey, find me every document related to this because I'm going to be deposing on the other side tomorrow and I need all these documents. You can't do that in today's paper deposition. Now I'd like to turn it back over to Kevin, who's going to close our time together.
Thanks, Thadd. Well, that went pretty quick. And we're going to take your questions in just a moment. A couple of you have used the chat pane to enter your questions. If you do have questions, now is the time to enter those into the questions pane. We'll take those in a moment. But we've covered a lot of territory today. We've looked at the importance of depositions as the new trial, and appreciate those stories from Shawn. We reviewed how eDiscovery has revolutionized litigation. We've highlighted the pain caused by the fact that paper is still used in the deposition despite efficiencies gained through the eDiscovery revolution. We've shown how using a digital exhibit system can alleviate the pain and bring new levels of convenience, efficiency, cost savings, and accessibility to the deposition. We've shown you how to prepare your documents for use as electronic exhibits. And we've talked about what are the must-haves and the nice-to-haves when selecting an electronic exhibit system so that you can leverage eDiscovery efficiencies at your depositions with electronic exhibits. We are about to take your take your questions, but if after this call you'd like more information or a demonstration of eDepose, please reach out to one of us, any of us, using the contact information here. And we're going to talk about CLE information right after our Q&A session. With that, we can take some questions, and I only see a couple, so either that means there are no questions or a few questions. Oh, here's a couple rolling in. One question from Jeffrey: could you go over the advantages and disadvantages of using native electronic documents as exhibits, for example, using a native Excel spreadsheet that will not convert easily to PDF? I'm going to allow Thadd to address that.
Actually, let me jump in there. This is Shawn. So usually, I think the first thing that we should do is revert back to kind of the paper, the normal paper process. Odds are, if you've got an Excel spreadsheet that won't convert easily to PDF, it probably won't easily print either, or you're not wanting to print it. I had a client that maintained data, for example, in these spreadsheets that were hundreds of columns wide, and if you tried to print them out, they'd be tens of thousands of pages long too. So obviously, you're not going to be dealing with those in paper format anyway. And I think, with some exceptions, most of the time you're having to figure out how to deal with Excel spreadsheets because a lot of them just weren't meant to be printed out. And so in kind of typical practice, if you've got a document like that, you're already having to figure out a way to use it natively. for example. You've emailed it around, or you just have an agreement among counsel that you're all going to be opening up that document on your laptop. You're sort of deviating from the normal way of dealing with things. You might have a placeholder document that you use for, to kind of put in the record at the deposition. This Exhibit 13 was this one spreadsheet, but it's not going to end up in, being scanned like all the other documents. With an electronic exhibit system, you're probably going to deal with the same sorts of things, unless for some reason you can use native documents directly in that system. There are issues with using electronic documents that way, in terms of everybody being able to view them at once. Everybody, and I think more importantly, being able to track them in the same way that you normally do. So we tend to think of Excel spreadsheets, for example, as they're an outlier. If you wouldn't use them in paper form in the normal kind of process, you're probably not going to use them in an electronic exhibit system either, directly in that form. You're probably going to use them in the workaround, the same sort of workaround that you're using them currently.
Okay, a couple questions from Lewis here, and Shawn, I think maybe I'll give these to you as well. How are the courts responding to the eDiscovery revolution? Are they prepared for use of electronic documents at trial? What's your experience? And then related to trial, has authentication at trial been an issue?
That is a good question. Our courts responding to the eDiscovery revolution, I think we're pretty far down the road in terms of everything going electronic and in the larger eDiscovery process, and dealing with originals of documents as their electronic versions, for example, and dealing with copies of those as electronic copies, and not having to really ever bring them down to paper format. Dealing with them at trial is probably a different animal, and it depends what court you're in. Some courts are much further along than others in this, but I think by and large, when you get right down to trial, most courts are lagging behind being able to use documents in electronic format in that setting, except where you're just using an electronic system to display documents. It's a little different than in the deposition context. The distinction between deposition and trial, I think, is important to keep in mind. By the time you get to trial, everybody knows, because you put all the documents on your trial list, your exhibit list, what everybody's using. There's no element of surprise in terms of what documents are going to be shown. You're going to be arguing about what documents can be shown, maybe up to the point where they're used, but it's more about the presentation of those documents and how they get in, and with which witnesses, and those things when it comes to trial. In the deposition room, there still is the element of surprise, in the sense of you're strategically using those documents, and not, you don't want to just sort of open your case of documents to the other side and give them a preview of what you're going to be using. It's very important to be able to kind of lead a witness down the trail about a certain topic, and then at the last minute kind of pull out that email that they authored, and you're going to confront them with that. And they don't necessarily know that's coming. Their counsel might, and the other people in the room might, but they might not. So there are different sort of strategic considerations when it comes to the deposition room, and that's why I think it's really important to look at the workflow of electronic document, electronic exhibit system, whether it matches with the typical workflow for depositions, or whether you're, are you really just essentially trying to shoehorn trial exhibit, display technology into the deposition room, and that probably won't work.
Okay, a question from...
And just one thing, this is Thadd, just one thing sorry, Kevin, I was going to add one thing on Lewis's question there. On the authentication, with a good exhibit system, if an official exhibit gets introduced and 6 different parties receive that document and they all open it and start marking it up and doing their work product, that's basically going to save a copy. The official exhibit is going to be unaltered. So the system will actually authenticate, and everyone that was involved in that deposition will know that this official exhibit was the official exhibit to the deposition, and that can be tracked all the way through the life cycle of the case.
Thanks, Thadd. Question from Laura: how would the court reporter mark the official copy of exhibits? So in many digital deposition systems, there's a provision to mark the exhibit within the workflow of introducing a document, and so if you'd like more detail in terms of how that works on a play-by-play basis, we're glad to show you exactly how that works in our system. But yeah, that is a function of typically of the electronic exhibit software.
Yeah, and let me chime in there too. The role of the court reporter, I think, is important to understand too, in that most of what the court reporter does in terms of taking down the transcript of what's said in the room, and what you do with the transcript and how you have to treat the parties with regard to it, all of that is very heavily, typically very heavily covered in state codes and rules of civil procedure and the like. But when it comes to the exhibits, almost always what we do in the deposition room with exhibits is a matter of custom and practice. It's really not a matter of code, and a lot of that comes down to who is the only person that right now you would trust with walking away with that stack of paper exhibits that has the stickers on them. And everybody would trust the court reporter to do that. But the court reporter doesn't typically have a role, with a very few exceptions that are kind of out on the margins, with regard to exhibits, an official role. So the system, allowing a system or the attorney who's running it to stamp documents is really consistent with code, and it's more a matter of kind of leaving the court reporter to do what they're mainly there to do, which is take down the transcript.
All right, we have come to the end of the questions that I see. If you do have any last-second questions, now would be the time to enter them. Of course, if you have one that wakes you up tonight, feel free to send us an email at one of the email addresses that you see here, and love to answer additional questions for you, or give you a product demo, or just clarify anything that you may have heard today. One more question just came in. Heather's is asking, who normally controls the security settings and rights to the electronic deposition database? Who wants to take that?
I can take that. So it probably depends on what system you're using. I think again, kind of consistent with how attorneys are used to dealing with electronic databases, eDiscovery databases. We think it's ideal and preferable if whoever's kind of managing that for your case team can set all of that. So you have access to your own database, you can set up your own users, you can set up who has access to what. But when it comes right down to it, your account is your account, and you're not going to be sharing documents just by virtue of logging into a deposition session, for example. You want to make sure that all of those are controlled. The security is such that access to those documents are limited to your team.
Another question that just came in, is there a way to make an electronic copy of exhibits available to witness counsel during the deposition, but not allow that counsel to walk away from the deposition with the electronic copies of the exhibits?
Is there a way to make an electronic copy? I think that would be, well, I'll say this. I'm not sure that ability exists out there aside from, say, for example, you're showing a document to them, you know, via video conferencing or what have you. But really, if you're trying to do that, you're basically deviating from what current expectations are. So opposing counsel right now, they get a courtesy copy of the document that gets, of the exhibit that gets marked, gets handed around, and they can work with it. They can be looking at page 5 when the witness is on page 2. And that's really important to that process. Everybody expects that. Everybody's annoyed if you don't bring in enough copies with you, for example. If I anticipate that there are going to be 6 people total and 2 extra people show up, now I have to sort of apologize for not having enough copies, and people are sharing and those things. So if you're moving from paper to electronic, you're going to have to be dealing with current expectations. And, you know, are there situations where you can, you know, opposing counsel would be satisfied with just watching something? Maybe, but a lot of times they're not. They're going to be expecting, you know, what they get now, essentially.
Shawn, Thadd, Kevin, excellent job. Thank you very much for a great presentation. You all did really well. All right, everyone, again, thank you very much for being here, and we'll see you next time. Bye.